Hello there, John Cuturillo here, the counsellor of your listener. Thank you for joining me for this episode, and thank you to everyone who makes it possible for me to live my vision every day. In today's episode, I'm going to be making a philosophical reflection on the questionable logic of our laws and our legal systems. Now, before we begin, allow me to make some factors clear. First of all, nothing that you find on the internet or in the media is advice ever. If you have concerns of any nature, legal or otherwise, please consult a professional whom you trust. And also importantly, do not ever take what you find in the media as an excuse to go break the law. As I always say, be a law-abiding citizen. We have obligations. I'm not suggesting that I believe in breaking the laws, but only by questioning what we assume to be the ultimate truth or taking for granted can we actually learn about how life works and how people work. So this is the reason I make these reflections. Law is something that we create, and we can learn much about how the mind works and how society works by extension by looking at what human minds have created. I can't say that this is in the majority of cases. I can't say how widespread this is. It's hard to know that with the sheer depth and breadth of the law that exists, but quite often laws and legal systems do lack logic, and often what happens is the law ignores the essence or the key quality of a particular issue and adds layers and layers of reification, that is to say treating something as different because we think about it differently, as layers and layers of reification that complicates how people interact with the law. Certain matters do have innate sense to them. They have a certain logic that can't be simplified or explained by any phenomenon other than itself. And often the law, being something that we create, ignores a lot of that and complicates it to the point that it becomes less practical or less logical. We have laws for a reason. The problem with the mind is that one of the qualities of how our minds work, which can also be a flaw, is that the mind doesn't tend to operate well without guiding principles. And every facet of human existence, from how we organise our work schedule to how we do our housework to how we operate a society, all of those endeavours on the micro level and on the macro level require some kind of guiding principles, and the larger the activity, arguably, the more guiding principles are involved. What we often don't realise is that without a set of guiding principles and a set of concepts which we hold to be the truth and use as our standard against which we judge behaviour, not only would our minds be in chaos, but our society would be in chaos. So we need a standard against which we can judge decisions and behaviour to ensure that all of us are working in ways that keep from infringing on each other's rights and causing great harm to each other. Another reason is what often is described as the slippery slope phenomenon, which is a tendency that our mind has to make decisions about how to deal with a particular situation based on past decisions. And what often happens is when we change how we respond to a particular situation, that sets a new precedent that can be used to dictate in the future how that situation should be handled. But if we are forever changing that standard, then we are forever comparing our present behaviour to a standard that is never constant, which means that quickly that standard can change and actually degenerate. And that has happened throughout history. When it happens within one person and there is enough of a widespread phenomenon to affect people similarly, it happens throughout society. Because of that, laws keep us from lowering certain standards which should never be lowered to protect people. A good example of that is before you reach a certain age, you don't yet have the cognitive capacity to decide whether sexual intercourse is appropriate or whether it's safe. Realistically speaking, the level of intellectual maturity between a 17-year-old and an 18-year-old isn't particularly large, but in developed societies, it's illegal to have sexual relations with a 17-year-old if you're an adult, that is to say, over the age of 18. Now, there are some grey areas around that, and I believe there are some provisions in certain states of Australia that state that the difference can't be more than 2 years, but that's a different story. If you're a 49-year-old person having sexual relations with a 17-year-old, it is perfectly possible that their level of maturity allows them to judge quite accurately whether sexual relations are safe. But there's a good reason why that's illegal. Because if we allow our standards to become arbitrary and any person can simply decide this person seems old enough and wise enough to know what's safe, we can undertake this type of relation, then what's to stop us from then in the future allowing people to make that judgment for younger individuals? And then it eventually lowers to the point that adults can very easily take advantage of children, and that has happened throughout history. So we need hard standards. We need to remove ambiguity because the human mind does not deal well with ambiguity. There are good reasons to have laws. The problem is that laws quite frequently complicate situations by having a large number of different provisions, a large number of different contingencies, to the point that we need professionals, lawyers, to help us understand them if we have been accused of breaking a law or if we have to take action against somebody else because they've broken a law in a way that harms us. In theory, if we lived in a world in which people all acted in good faith, we basically wouldn't need laws because everybody would be wise enough then to know what was innately logical and good and what was innately illogical and bad, and they would follow what was good. But hypothetically, if we lived in a society in which people still did wrong but were willing to admit when they did wrong, laws would be significantly simpler because when somebody was caught, they would simply say, okay, I did it. And yet, throughout history, we've seen any number of legal cases. And again, I'm not an expert on law, so I'm not going to be an encyclopedic source of that, but we have seen legal cases in which the argument put before the courts is not whether or not the person actually did the act, but whether the case was carried out in a manner that was compliant with the law, thereby making it fair according to the person making the argument, or whether the investigation was carried out in a way that was compliant, or the reason for which the person did it that should somehow entitle them to leniency before the law. You have lawyers arguing over all these different intricacies of how the law works and what's allowed and what's not allowed, but completely ignoring the essence of what actually happened. And if people acted in good faith, and if we were truly willing to take responsibility for the ambiguities and the risks in the world, we wouldn't have to have those complications because we would simply accept the objective truth of a situation. Now, there are also situations in which, of course, people's perceptions of the truth differ, but just because you have a perception of the truth, it doesn't mean it's the truth. It's your perception, and we have throughout history, again, consistently mistaken our opinions for something which is objectively true and saying, well, I believe it, therefore it's valid, or therefore I have a right to leniency or to the benefit of the doubt because I believed it. But certain ideas are more objectively logical than others and more objectively good than others. If we were truly willing to recognise this, a lot of these complications wouldn't exist. And ultimately, we created this problem by creating complicated legal systems. It's not to say that the laws themselves relate to invented matters always. For example, there is a law against murder. Now, murder is not bad because we believe it's bad. It's innately bad. The morality of that is inherent. But there are other matters for which we have actually created the problem and then created laws in an attempt to address it. Or for matters that are innately logical, for example, that murder is wrong, there are complications that may lead investigations and cases to take longer than they could otherwise take because we're not necessarily arguing over whether this person committed murder, we're arguing over if the law was applied in a way that warrants this consequence or that consequence. We're arguing over intricacies, technicalities. Make no mistake, it is a flaw that we have to think this way. I'm not suggesting that we can just destroy all our laws and destroy the fabric of society and create a new system. That would be chaos, especially considering, as I just explained, we need standards in order to judge what is appropriate behaviour. But let us also reflect on the fact that we have great potential to think logically and to think with clarity. And if we thought with clarity more often, not just in the law, but in many aspects of our life, we would be able to eliminate much of the mental clutter. We would be able to eliminate much of the complexity in our life and actually achieve things with greater efficiency and greater competence. So let's apply that philosophical view to the law. And let's look at some aspects of legal systems that tend to reflect this problem. First, let's discuss parts of the law or particular laws that overcomplicate acts and how we perceive them. Often there are broad categories of different types of crime, and then there are particular crimes or criminal codes within those broad categories. What often happens is the law defines different types of crimes and different types of penalties that refer to somebody actually engaging in a similar type of behaviour with a similar type of nature or essence and a similar type of motive. It's quite irrational often to invent labels and categories just for the sake of inventing labels and categories when the actual essence of the act is very similar. Let's look at some examples. In terms of sex crimes, the crimes of what we call rape, sexual assault, child molestation, the possession or production of child pornography, they all have different categories under the law. Now, I don't know exactly what the penalties for them are, but what's the common essence behind all of them? All of those acts involve committing behaviours of a sexual nature that, in a way that affects an individual that did not or cannot morally and or legally consent to the acts. The essence in all of those cases was that the person who committed the act, barring any mental illness which may be a mitigating circumstance, the person who committed the act was reckless enough to put their desire for sexual gratification over the welfare of the person involved. In the name of thinking clearly, and we're purely looking at this from a logical perspective, why do you need different categories? The essence of those acts was somebody committed a sexual behaviour against somebody who could not consent or did not consent, and in doing so placed their own sexual desires ahead of the welfare of somebody else. However you perceive it or whatever your beliefs are, that is the essence and the objective truth of the act. Now, yes, those different acts may have different consequences. For example, rape is considered sexual penetration, whereas child molestation doesn't inherently involve sexual penetration. But that's largely beside the point. Treating an instance as being different just because it doesn't involve one minute part of the behaviour in this case is completely irrelevant in my view, because just because you don't penetrate a child doesn't mean that your sexual contact hasn't affected them physically and mentally in quite a severe manner, or doesn't have the potential to. We are constantly trying to categorise different phenomena and trying to complicate it with different intellectual analyses, but we ignore the basic nature and the basic objective truth. And quite frankly, if a person was brought before the court for rape or for child molestation or for the possession or production of child pornography, the underlying psychological characteristics that led them to commit those acts probably would make them equally dangerous in any case. Think about also crimes that involve what we call trespass against the person, that is to say, actions that harm another person. Think about, for example, assault and battery, where assault is the threat of using force to harm someone and battery is the actual application of force. And then we have common and minor assaults and battery, we have aggravated assaults, we have dangerous driving causing injury, we have robbery. Think about the essence of, again, any of these acts. Somebody has behaved in such a way, either deliberately or by being recklessly indifferent, in other words, not caring enough to watch their behaviour so as to allow it to become dangerous, and their behaviours have caused harm to another person. Yes, the level of harm that is caused by these different types of crimes can vary, but think about a couple of factors. First of all, the person who is on the receiving end of that, especially if it's a random attack, how are they supposed to know that you didn't intend harm but just intended to scare them? Or how do we know that the injuries or the effect on the person wasn't actually more severe only because the criminal was incompetent at executing the actions? If they had have been a little smarter, a little more competent, maybe the actions would have been worse and they may have ended up killing them, especially when it comes to dangerous driving. The essence of the act, what actually precipitated the act, was someone intentionally wanted to hurt another person, or they cared so little about someone else's welfare that they were willing to allow their behaviour to become dangerous. The fact that they didn't cause more harm than they did is down to luck. Because when you put yourself in the position to hurt another person, it's very easy for you to make a mistake in judgment if you didn't intend to harm them so much and actually end up harming them more. The fact that you are willing to put yourself in that position makes you a danger. The essence of it is that danger and your willingness to do so. Similar with homicide, murder, manslaughter, dangerous driving causing death. They're different grades of offence, but I'm predicting these are the types of situations in which there is There were arguments in court about whether the person had the right level of intent for it to be murder, or was it only manslaughter. They didn't have the right level of intent. They were just being reckless, or they only intended to harm the person, but they didn't intend to kill them. What's the essence? A person like with assault, they put themselves in a position in which they were prepared to behave in such a manner that any logical person, again bar any mental illness involvement, should have known posed a risk of causing death. Why complicate it with all these different labels? And why deny the reality of it? Also think about property crimes, theft, robbery, fraud, embezzlement, identity theft. We have different labels for them, but really the essence of them is exactly the same. Somebody took something belonging to someone else. Now, you could also argue that different levels of impact on the victim could attract different penalties. That's a different story, but the fact that we have to categorize everything to the point that we lose the essence is very much a flaw in the way we look at these issues. Another aspect of the law is the adversarial system, which isn't how the law operates in every country, but it operates in Australia. And for those who may not know, the adversarial system is the approach to justice in which there are two parties, the plaintiff or the prosecution and the defendant, who are attempting to win the case. The purpose of a trial under an adversarial system in the judiciary, or the court or arbitration, in other words, is to win the case. The alternate system is the inquisitorial system, which operates in some other countries, including some European countries. An analysis of the two is beyond the scope of this discussion, but the problem with treating winning as the goal is that effectively each party, when they are faced with this particular goal, has to behave in such a manner as to convince people that they are in the right, when what they are arguing is in the right is not necessarily the objective reality or the objective logic of the situation. Something that also we need to acknowledge is that when we are given certain information or we are exposed to a certain goal, especially if a lot is resting on that goal, if our achievement of a particular goal has positive consequences for us, but not achieving it might have negative consequences. Due to confirmation bias and heuristics or mental shortcuts, our mind is going to be attuned to the information that supports that goal and what is going to facilitate the behaviour in order to achieve it. That means that if you are the prosecutor on a criminal case in which, for political reasons, you are determined to succeed in prosecuting a particular suspect, even if they haven't done anything that is objectively wrong or they haven't broken the law, your mind is going to be more attuned to recognising and amplifying in importance the information and the ideas that support that goal and your perception of that person as being the party in the wrong. But it's going to be less attuned, leading you to ignore the information that suggests that maybe your evaluation of that case is wrong. Your goals can be influenced by so many motives, including political motives, ideological motives, that the idea of winning is not the most logical one in that case. More often than not, there is an objective reality to a situation, as much as we like to think that there isn't and that perception is everything. The role of a person in legal authority who is assumed to be in the right, the law and government are assumed to be the people in the right, the people on the right sides of the law, discovering the objective truth should be their only goal, not just winning. The other problem is that, as I'm sure we all know, if the goal is to win, then the person who wins could well be the person who can afford to pay the lawyer who is skilled enough to convince the court that they're in the right, not the person who is objectively in the right, because you're being judged by humans and humans have flawed thinking. Let's consider cases of self-defense, more from the United States than Australia, because Australia has different laws regarding self-defense. And again, pay strict attention to my analysis here. I'm not suggesting what you should do in self-defense situations. That's a completely different discussion. I'm just using this as an example. What has often happened in the United States in instances in which individuals have been charged with murder after having shot somebody in self-defense is the prosecution will ask the accused, did you shoot that person to kill? This is hearsay, but I'm told. If the prosecution asks you that and you answer yes, then you have just effectively admitted that you intended to kill that person before you shot them. Now, logically speaking, if the person only shot after the other person posed a threat to them, then logically that person had justification for doing it. But at the same time, if the assailant hadn't have attacked them or posed a threat to them, that person would not have shot them, in a case where it is actually self-defense. But often the reason why the prosecution would ask, did you shoot to kill, is that they're expecting the person to say yes, because often a person can't think on the spot very quickly, and it's hard for them to discern the different thoughts that they're having. In that person's mind, they knew that a gun is a lethal weapon, and they knew that if they shot someone, they were likely to kill them. So if someone asks, did you shoot to kill? Often there's a good possibility that they answered yes, because what they were actually thinking was, yes, I did undertake an action which I knew would kill someone, but I had no premeditated plan to kill them. I only shot them because they acted in such a way to threaten my safety. And that's why in the United States, defendants are often advised to say, no, I didn't shoot to kill, I shot to stop them from harming me. But if you are actually interested in understanding the truth, the question you would ask isn't, did you shoot to kill, but why did you shoot that person? It's irrational to treat that situation as a competition in which one person, the prosecution in this case, has already made up their mind that this person is guilty. Because what leads you to believe that that person is guilty of an immoral act? They claim they shot in self-defense. Perhaps witnesses are able to testify that they shot in self-defense. Why are you trying to lead the case to go in your direction when your only goal should be to discover the objective truth and to have the person suffer consequences if they did indeed commit an immoral act? Another example of this is in medical and health practice liability. Now, I'm not going to deny that there are unfortunately some massively incompetent medical practitioners in existence. There's incompetence in every industry. We can't deny that. But all too often, medical practitioners are ultra strict on their compliance and how they treat their patients, not necessarily because they lack confidence in their ability to do their job, or they lack confidence in the patient's intention to act in good faith, but because they're scared that if something goes wrong, they're going to be held liable. And for example, I've heard tell from the medical industry, and again, this is purely hearsay, but I've heard tell from the medical industry that certain practitioners are becoming perhaps reluctant to prescribe certain types of medication for specific types of conditions, even though the likely benefits of the medication outweigh the risks and may even potentially prevent serious illness from developing in their patients. And the benefits do quite reasonably outweigh the risks, but there have been cited cases of those medications causing harm when taken in the long term. And so what they're afraid of is that even though they've explained to the patient, these are the risks, but these are the benefits, you get to make the choice, the patient could still sue them if long-term harm comes to them from taking that medication. Now, if a person acts recklessly, for example, if a doctor prescribes bleach for treating an infection and says, don't worry, it's safe, then yes, absolutely that person should be not just liable for civil damages, but guilty of criminal negligence, because that's an absolutely horrendously stupid thing to do. But in almost any endeavour that you do in life, there is some risk, and every medication has risks involved in it. If a doctor describes to you inaccurately, this is the risk, but there are benefits as well, and this is approximately the likelihood of the risks actualising, this is approximately the likelihood of the benefits actualising, you have no choice but to make a choice. If you choose to take the medication and a side effect does actualise, then you could argue, yes, maybe the doctor didn't make it clear enough what the actual risk of these side effects were, but then how do you calculate that? How do you quantify it? And at the same time, if you decide not to take the medication to avoid the side effects and further harm comes to you, does that then give you the right to sue the doctor for not forcing you to take the medication because the doctor didn't make it clear enough just what the risks were if I didn't take it? Literally every choice that you have in life has a risk attached to it. Why does someone have to be at fault? And it's the same in the psychotherapy industry. And I'm not suggesting that I do what I do just for compliance, all right? I genuinely never want to see a client come to harm. But often the reason that so many psychotherapists and similar professionals seem to be quite fastidious about compliance and seem to be quite paranoid about their clients' well-being. For example, I told a story in one of my episodes some time ago in which I arrived at my psychologist's office for therapy, and they noticed a brace on my wrist, which was there because my wrist was sore. I think I might have sprained it, and I was just wearing it there for support. But they looked at me and said, "What happened to your wrist?" And they were quite concerned, and I said, "Oh, I just sprained it." And they looked like they didn't believe me. I could read the thoughts on their face. "Oh no, he's committed self-harm by cutting himself. Now I have to make a report, or now I have to do more paperwork." I can't say how many medical professionals have been found liable on this basis, but I'm willing to predict that the reason they're so paranoid is that they're concerned that someone or someone's family is going to sue them if harm comes to them. Again, if you behave recklessly with a patient, then of course you should absolutely face consequences, but life isn't so regimented as to be able to delineate who's at fault all the time. Every choice that you make is going to involve some risk. Why does someone have to be held at fault all the time? It's not reasonable or innately logical to say that somebody is always in fault, because to say that someone's always at fault is to suggest that there is always someone who has so much control of that situation that they can practically guarantee an outcome by making a particular choice. To say that one person always has to be at fault and must pay the consequences for someone's choice, even after they've been informed of the risks, is quite a problematic way to look at the world, because think about how we could extrapolate that logic. Using that logic, you could blame everyone. You could blame so many different people that we don't already blame for somebody else's misfortune using that. It's not to say that people's misfortune isn't tragic, but one of our unconscious tendencies is to think that the world is a perfectly orderly place in which everything makes sense. And in a world in which theoretically everything makes sense, we can always blame someone. Someone is always at fault. Everything always happens for a logical reason. Someone caused it to happen. But that's not reality. There are many ambiguities in the world. It's impossible to account for all of them and completely eliminate risk. A related phenomenon is instances in the law in which people have been assigned blame where it isn't reasonable based on faulty logic or other people's actions. Now, some of us may be familiar with the stories that were circulated at one time about burglars or people intruding onto other people's properties who were injured or shot in self-defense or similar, who later were able to sue the property owner. Now, warning, there is a lot of mixed information about this available. Some of those stories apparently were false, so take it for what it is. But in instances where it actually happened, people have actually argued, well, the property was unsafe. The objectively logical question to the intruder is, why were you on a property where you weren't meant to be? No one told you to go there. And what's more, you knew it was wrong. So why are you trying to penalise someone else because of your choices? We don't commit burglary by accident. A significantly more ambiguous but still questionable situation is copyright laws. Now, again, I'm not suggesting that people's intellectual property isn't important or to suggest that we shouldn't protect intellectual property, but there have been numerous instances in history of people being sued for copyright infringement where they didn't realise that they were infringing someone else's copyright. For example, composers writing songs that they didn't realise were too similar to somebody else's songs. How could you actually be creative if you're scared of accidentally infringing on someone else's intellectual property and potentially getting yourself in trouble? Copyright infringement or infringing on someone else's property is morally wrong when you do it deliberately, because you are making a mockery of that person's effort. When someone creates something, often it takes a great lot of mental effort or physical effort. To have someone profit off of that when it's your effort that made it is morally wrong. At least they should ask you first. It would be hard to enforce a law that stated that you're only liable for copyright infringement if you intended it, because a defendant could easily say, well, I didn't intend it. And who can demonstrate objectively that you did? But that's not to say that the law is without fault. There are only so many ideas that can exist in the world. Yes, imagination is quite broad and quite fluid, but for example, when creating music, there are only so many notes. There are only so many sounds, and we are products of what we absorb in terms of our influences. I'm sure that there are plenty of composers who have never heard somebody else's particular song, but written a song that sounds just like it because they were experimenting with their instrument one day, improvising, and they all of a sudden stumbled on a set of chords, a set of notes that sounded fantastic to their ears. Slightly more questionable to me is the idea of being able to sell intellectual property. Now, again, people have the right to do with their property as they wish, but there have been cases where an artist has deceased and their family then sues somebody else for copyright infringement. That may be legal, but think about the nature of creation. You put effort into creation. You may then give someone the right to benefit from that, but if I, for example, write a song and it becomes famous and I didn't realise that it was too similar to someone else's and that other creator sues me or their estate sues me, how reasonable is it for me to have to suffer because I did something that humans naturally want to do, which is create, and without any malice or any intention of violating someone else's rights. If I'm driving my car down the road and someone jumps in front of it and I don't have time to stop, it's reasonable for me to assume that if I'm a good driver, I should be able to drive on the road, obey the laws, and not be responsible for someone else's harm. That person jumped in front of my car, but if I'm driving in such a manner as to disobey the rules and to disobey logic, and I hurt someone, yes, then I am responsible for that harm. In order to engage in life, you should have reasonable assurance that if you follow certain standards, that you won't be liable for harm to someone else, or you won't be forced to be, or you won't be forced to be penalised for your actions. By the logic of copyright law, if you want to be free from causing supposed harm to someone else by accidentally stealing their intellectual property in such a way as to make you liable, you would actually have to refrain from creating entirely. But it is part of human nature to create, and if we didn't create, the world would be a dysfunctional place. We are constantly creating, we're constantly advancing. So you tell me, how do you actually be a good, upstanding, law-abiding citizen and be a creator at the same time when there's so much risk that you could be inadvertently infringing on someone else's property? So, thank you for joining me for this reflection. As usual, never take what you find in the media as advice. This is not legal advice. Be a law-abiding citizen. You know what your obligations are, and if you don't, get advice. And if you have concerns about yourself or anyone else, seek professional advice. If you have been inspired by something that you heard today, or you have an idea for something that you'd like to hear discussed in my program, or you'd like to be a guest, please contact me. I would love to hear from you. And until next time, take care.